Good morning. I'm Pam Bean with Montana Fair Housing. We're a private nonprofit that addresses discrimination in housing through education outreach, dispute resolution, and when necessary, enforcement activities. Our office is located in Butte, and we do have a website and an email address available for you on this first slide. I need to let you know that I am not an attorney, so anything I share today is not to be construed as a legal opinion. And for a legal opinion, I encourage you to contact your own private counsel. Again, we're a private nonprofit. We serve the entire state of Montana, provide education and outreach, provide information in events like this or through workshops, presentations, also attend many open community events. We provide dispute resolution services when folks are interested in resolving an issue pre-filing of an administrative or court enforcement action. Finally, we do also conduct investigations of housing discrimination and, when necessary, assist victims of housing discrimination in filing complaints with the Department of Housing and Urban Development, the Human Rights Bureau, and on occasion also in court. One thing I like to make sure folks are aware of is that the first Civil Rights Act was passed in 1866 and prohibited discrimination on the basis of race, color, and national origin. The one thing that's important about this law to remember is there are no exemptions for housing providers. So in no event can a housing provider deny someone because of their race, color, or national origin. Then in 1968, the Federal Fair Housing Act was passed. Originally, it prohibited discrimination in housing only on the basis of race, color, national origin, and religion. In 1974, it was amended to prohibit discrimination on the basis of sex, and the last amendments occurred in 1988, which added disability and familial status as protected classes, but also, importantly, created the administrative process, allowing for folks to file complaints with HUD without having to get an attorney or go into court. So it made it much more affordable for victims to pursue their civil rights. In addition to that process, the amendments added civil penalties that can be assessed by an administrative law judge should an enforcement action not conciliate with HUD and a charge be issued. Then the case is referred to the United States Secretary of HUD. At that time, folks elect to pursue the case either in federal court or with an administrative law judge, and the judge is able to assess civil penalties against the housing provider to reimburse the United States Treasury for the cost of having to pursue those actions. In addition to the Federal Fair Housing Act, we have the Montana Human Rights Act, which adds 3 more protected classes, which is marital status, age, and creed. Marital status protects persons whether they're married, unmarried, or divorced. Age prohibits a housing provider from identifying a group of folks based on age that they do not want to serve. And then creed protects folks from discrimination on the basis of having a strongly held belief. I would also like to add that there are nuances within the protected classes, and some things we can fit in there, some things we cannot. For example, sex discrimination while offering protections for domestic violence victims and sexually harassed victims. It does not include protections for the LGBTQ community. Now, on occasion, if a housing provider has denied services to someone because they're lesbian, we're able to fit that under sex because lesbians are female. So if someone, for example, will provide services to lesbians but not people who are gay, we can make that argument. It also is not covered under marital status. I've had a few conversations with folks in the LGBTQ community who thought maybe it could fit under marital status. And I'm happy to have more conversations about that, but I have not seen how we could make an effective argument on that basis. There are local ordinances in communities, one being Missoula, that prohibits discrimination on the basis of sexual orientation and gender identity. So that can be helpful to look to in the event that different treatment is occurring on that basis. In regards to creed, to elaborate on that some more, primarily this issue comes up in regards to natives who are wanting to sage or smudge their units, and a housing provider will have a no smoking unit, a no smoking policy. Usually how the issue arises is a neighbor contacts the landlord indicating the person next door is smoking pot. They go check it out and they are really smudging. And this is handled a lot like accommodation issues for folks with disabilities, because we'll talk back and forth, try to figure out if there's a way that this household can smudge in support of their belief systems and balance that with the needs of surrounding households concerned about potential danger of smoke in the air. Generally, we've been successful about resolving that. In some cases, one of the ways it's resolved is that one of the households transfers to another unit or gets out of their lease to find another unit that works best for them. Particularly if there is a neighboring household that has health issues such as asthma, that type of thing that can cause some interference. So sometimes balancing folks' civil rights creates some tension, and we have to get creative, but we really work to find answers, and there's a lot of good resources out there to come up with ideas to assist in making sure everyone's rights are respected and upheld. Just to share a little bit more information in regards to familial status, this prohibits discrimination in households because of the presence of children under the age of 18 or pregnancy. And this also includes foster care. A housing provider cannot charge you more for rent a month because you have more children, or more per child because of this. I've seen it both ways. He or she also can't evict you because you have a baby. So even in a studio, for example, which is considered a two-bedroom unit, or excuse me, a one-bedroom unit, two people can live in that unit. And say they get pregnant, and the day after they bring baby home, they receive an eviction notice on their door. A housing provider cannot evict that household for being over occupancy until the child is at least 2 years old. So that is important to know for a lot of folks who have faced similar situations. The age prohibitions against discrimination don't just cover a specific age. It's any age group. If a housing provider indicates that he or she will not rent to people age 18 to 30, that's a violation. But I've also seen some, which I still don't understand to this day, where they've said 35 to 45. We're not renting to that age group. So age covers broadly. It's not just families with kids. In communities where they are limiting the number of unrelated people living together, there are concerns that that leads to age discrimination, because unrelated students often share housing to be able to afford to live and to go to school. There is also concern that it affects households based on race, color, national origin, and disability, because statistically those households have lower incomes and share housing. So there's a lot of ways potential violations can be approached given the right set of facts. Pursuing complaints of housing discrimination is not an easy thing for a lot of folks to do. It can be time-consuming in spurts and can last many years before a resolution is reached. And we try to provide the support, the encouragement, the interference at times to allow people to comfortably as possible get through that process and get the justice that they deserve.
Pam, could you talk a little bit about like a landlord either saying no college students, or we also have these private developments that are marketing to students, and whether they could say this is only for college students when they're like a private housing provider?
We actually addressed some of those issues in a case, I believe it was 3 years ago, down in Bozeman. And housing was developed at campus, but was open also to non-students if they qualified. And we proceeded with an action to address their definition of household, and were successful in addressing that. Now, should a housing provider have practices saying no students, in our opinion, that is likely an age violation. What we would do is take a look at the population at the university and get some stats about the age group, and that's generally in stats I've looked at 18 to 24, and then you can proceed and move forward with a state complaint based on age. Interestingly, I have seen a twist on that at least once, I'm thinking twice, where a housing provider preferred younger students over grad students. And I'm not quite, obviously some experience had occurred with grad students, so yeah. So there are, like I said, ways to address things outside the box. The Fair Housing Acts, both state and federal, cover all housing transactions and related services. So not only does it prohibit discrimination in rentals, but it also prohibits discrimination in sales, appraisal, lending, advertising, insurance, anything that prohibits a qualified household from getting the housing they want based on their protected class status. Discrimination happens in a lot of ways. Obviously, there can be direct denials where a provider just absolutely refuses to rent to someone in a protected class. I will not rent to folks who use wheelchairs. I will not rent to families with kids. Those are direct denials. Oftentimes what we see is different terms, conditions, or privileges being applied to certain households because of their protected class. I will rent to families with children, but I'm going to charge an additional deposit or higher rent. I will rent to native households, but I'm going to charge more rent per month. Also, in the application of approving requests for reasonable accommodations or modifications for folks with disabilities, sometimes we see housing providers attempt to assess fees for that. A housing provider is also prohibited from asking about somebody's protected class status, and that can be asking about what medication someone might take, what country they are from or their ancestors are from, what tribe they may be from, the number of children they have and or the ages of children. Those types of inquiries should not be made. Housing providers also may make discriminatory remarks, either in written form or verbally, and that is prohibited. If the remarks or the inquiries attempt to infer a limitation or a preference, that is going to be illegal under the Act also. And that can take place not only at application, but 6-7 months into a rental term. If a housing provider makes a discriminatory remark, that is covered. If someone is being coerced or intimidated or threatened because of their protected class status, that's also illegal. So if you have a neighbor who is, say you're in a wheelchair and they're putting bricks on the sidewalk or hoses so that you have no path of travel, that's coercion, intimidation, threats, harassment, and that's not okay. If they're harassing you because of your skin color or because of your sex, that is illegal as well. If a person pursues their rights under these acts, a housing provider is prohibited from retaliating against that household. So if someone files a complaint with HUD or the Human Rights Bureau or calls Montana Fair Housing for assistance in resolving a request for a reasonable accommodation for an animal, the housing provider cannot retaliate against that household for doing so, nor anyone who is serving as a witness. There are a lot of different areas covered under the protected classes we've talked about. For instance, a housing provider does have the right to establish an occupancy policy, which is limit the number of people residing in a unit. However, he or she has to comply with a guidance called the Keating Memo issued by HUD. And kind of a rule of thumb with that is it can be no stricter than 2 people per bedroom. It also talks about square footage, so if it's a really large room, more than 2 people may fit in there. If there's a bonus room like a den or a family room and has compliant egress and ingress, the household can argue that even though it's a two-bedroom house, they're going to use it as a three-bedroom, so 6 people would still fit within that occupancy limit. And the housing provider could not charge more for that. A lot of talk has occurred around immigration. And we need to remember that race, color, and national origin are protected classes. Now, when we talk about race, often folks look at that as identifying the color of someone's skin. And that may be part of it, but not everyone, for example, is African American. Some persons who are black may be from Jamaica. So race has a cultural component when you use that term. Color refers to the color of someone's skin, and national origin refers to where someone or someone's ancestors may be from, which may be German or Canadian or Mexican, Jewish. National origin also provides protections for Native Americans because reservations are considered a separate country. They have sovereignty. So when we look at immigration, there's broad protections from the protected classes. But in addition, HUD has issued guidance indicating that every person in the United States has a right to housing, regardless of where they're from or how they might have got here. So when someone makes application that might be here illegally or might be here legally but with a visa and not have social security numbers, for example, housing providers should look at alternative ways to see if that person meets their qualification criteria, such as getting background checks done, credit checks done. There are alternative ways to do that outside of just running a traditional background or credit report. And you cannot deny a qualified household solely based on the fact that they may not be a citizen in the United States. Harassment is also prohibited under the federal and the state fair housing laws, whether that is harassment by a housing provider, by his or her staff, or by neighbors and other residents. Under sex as a protected class, there is a great deal of case law prohibiting, supporting the prohibition of sexual harassment in housing. That can take the form of quid pro quo or hostile environment. Quid pro quo is a housing provider indicating to a tenant or a co-worker, which would be covered under employment laws, that he or she will cut the cost of the rental back, for example, if the tenant provides certain services. It can also be sexual harassment by way of creating a hostile environment, which may not involve the exchange of sexual services, but create an environment so uncomfortable that the tenant cannot tolerate it. And even when the housing provider is advised that this behavior is unwelcome, the housing provider does not stop. Then someone can file a complaint of discrimination. And if the offender is someone that the tenant, the victim of the harassment, is uncomfortable in reaching out to directly, he or she has the option of contacting like Montana Fair Housing and other advocacy groups, to address that situation on their behalf. Harassment can take place on the basis of race, color, national origin, disability, familial status, all of the protected classes. Domestic violence case law also has led to protections for victims of domestic violence. And housing providers are encouraged to have domestic violence policies. One reason I support it is because it's a very emotionally charged situation, and trying to come to a solution when people are very upset can be difficult. Federally funded properties are mandated to have a domestic violence policy. But in short, what the case law provides for is that a victim of domestic violence cannot be evicted because of the behavior of the offender. So if a victim is renting a unit with the offender and an event happens and police are called, you can't evict the entire household based on that event. If the victim reports to you she's a victim of domestic violence, you need to be, as a housing provider, working with that tenant to get protections in place, remove the offender from the lease. You can hold her accountable for damages that occurred prior to the offender being removed from the lease, but you cannot hold the victim accountable if the offender returns and kicks down the front door or throws a rock through the front window. That is then criminal, and the offender is responsible. Victims of domestic violence may also want to be let out of the lease early to move to an environment they feel safer in, or may be asked to transfer to one of your other units, so the offender does not know where she's at. There's been a lot of focus recently on how persons with criminal records can be provided protections. And there's varying degrees that might occur, but HUD has issued some guidance for housing providers requiring that a housing provider conduct a risk assessment if someone with a criminal record history comes in to apply, states, you know, I've got this, this, and this on my record, but here's the disposition information, here's the reasons why I'm no longer a risk, and here's some documentation from case managers, probation officers, parole officers, maybe recovery groups, showing how this person has complied with and made every effort to recover and not reoffend. Now, some persons with criminal records might also have obtained that record as a result of disability-related issues. So if someone was arrested and convicted while using alcohol or drugs and is now in recovery, they may request a reasonable accommodation. They may also request a reasonable accommodation, for instance, if a criminal record was incurred as a result of, for example, mental illness, and the person had not been diagnosed yet, so wasn't being treated, or maybe quit taking their medication and became psychotic. So they can make requests at that time to have the criminal record requirements waived and hopefully then be eligible for housing. At this time, there are no federal or state laws protecting persons with criminal records, but I do know there's some activity in local communities to try and get some protections in place. There's also an increase occurring, for example, in homeowners associations, creating nuisance orders or nuisance rules in an effort to create crime-free housing. While we all want to live in crime-free housing, we all want to live in areas where there's not nuisances per se, but some of these rules are becoming so strict. For example, someone has diabetes, and for a period of time while they're adjusting his or her medication, they go into diabetic comas. So ambulances are being called, and they're being deemed a nuisance by having the ambulance come. Or domestic violence victims who will call police for their own protection, which everyone has a right to. That's why we have police officers. So if you're experiencing issues with nuisance orders, crime-free housing rules, and they are a result of medical needs or protection needs, you can also give us a call, because those link back to protected class. There's also much discussion over the past few years about the affirmatively furthering fair housing rules. Those have been in the law since 1968. And when communities and states, Missoula being one of them, receives funds, community development block grant funding, they are supposed to use that funding in a way to reduce historic patterns of segregation. And these monies can be used for infrastructure, for busing, for housing, for employment. And no matter how the decision is made to use the money, the services need to be available to all areas of a community and to all of its residents. Buses shouldn't just serve a corner of the city. Housing shouldn't just be developed on one side of the city. If it's being done with these funds, it needs to be distributed throughout the community so the entire community benefits. Requests for reasonable accommodations and modifications for persons with disabilities. Montana Fair Housing spends a good 50–60% of our time on these issues. One being, we're not a very diverse state ethnically, racially. We also have a lot of agricultural and mining work still happening, so people are getting hurt more often. We're an aging population here in Montana, so there's a lot of age-related disabilities. We also have one of the highest numbers of vets per capita of any of the states, compared equally to Maine, I believe, was the last statistical information I saw. And a lot of our veterans, as we know, are coming back with not only physical injuries, but also emotional and psychological trauma that they are trying to cope with. So we've got a lot of folks with disabilities in Montana. So the law states you can't deny someone because they have a physical or a mental disability. And in order to provide folks with disabilities an equal opportunity to housing, sometimes a waiver or an alteration of a rule, policy, or procedure is necessary. So that's what a request for an accommodation is. I need an upright marker at my parking spot, and I need a parking spot on the closest accessible route because I have limited mobility, and it's hard for me to park at the other end of the parking lot. I can't make it all the way to the door. I need an early lease end for disability-related reasons because I'm going to have to go into the hospital for long term. That may be an accommodation. I need an assistance or a service animal to have an equal opportunity to housing, and I know that you have a no pets policy, and I'm asking you to waive that policy so that I can have this animal here. Now, housing providers do have the right to request some information to verify somebody has disability and what the need is for an accommodation request. They cannot require that you give them diagnosis or a list of medications or a description of what happens if you quit taking medications, but they have the right to enough information to understand there's a disability-related need and what the link is between this request and the need. They have the right to get this information from a healthcare provider, and a healthcare provider is defined very broadly. It doesn't have to be a psychiatrist. It doesn't have to be an MD. It can be a case manager. And oftentimes, in my opinion, case managers are very good to work with in this situation because they interact with the client much more often and frequently, and they're at their homes, understand the issues much better. So when you're requesting an accommodation, you get the information from your healthcare provider, and there are forms on our website your healthcare provider can use to verify disability. But you get that information, you take it to your housing provider or submit it an application, and then the provider has, rule of thumb is 10 business days to review that request. They have the opportunity to ask for clarification and the opportunity to suggest potential options outside of the request you specifically made. It's an interactive process to see what can hopefully work for both parties. You cannot begin implementing the request for the accommodation without the approval from the provider, meaning just because the therapist encouraged you to get an assistance animal for emotional support doesn't mean it's an automatic yes. You need to get the approval first from the provider. If you have trouble getting that approval, please call us. We spend a lot of time advocating on these issues for folks with disabilities, clarifying with healthcare providers the information a housing provider can and can't get, and then talking with housing providers about the circumstances under which they can deny or approve a request for an accommodation. Modifications for folks with disabilities are physical alterations to a unit. The need for a ramp, the need for a roll-in shower, and it currently has a tub shower unit. In open market housing, the landlord can require the household to pay for the modifications and place in an interest-bearing account monies to restore those modifications at move-out should the modifications interfere with the use of the unit by a following tenant without a disability. So, for example, if someone has put in a ramp and widened doors in a unit and put in a roll-in shower, I would argue that the ramp at the front door would not interfere with the use of the unit by someone with or without a disability and should be left. Widening the doors in a unit makes, I think, the unit much more marketable. I have never talked to a tenant that says they want thinner doors. Now, the roll-in shower, the housing provider could request be restored to original condition and the tub shower unit put back in. They don't have to require it, but they could, as the studies at least that I've seen indicate, most households prefer a tub shower unit. Modifications made to common and public areas cannot be required to be restored because it opens up the market for other folks with disabilities to be able to have access in these areas as well. The housing provider can require that the household purchase permits that may be necessary and also secure people to do the work that are trained, licensed, and capable to make sure it meets codes, etc. The last piece of the disability provisions included also a requirement that multifamily units be designed and constructed in a manner that are usable by someone in a wheelchair. This isn't the accessibility we would like to see for folks in wheelchairs, and certainly not the accessibility required by the Americans with Disabilities Act or Section 504 of the Rehab Act. Under the federal and state fair housing laws, it requires only that the unit be on an accessible route from parking, that the doors have a 32-inch clearance with lever handles, that there be a path of travel throughout the unit so someone in a wheelchair can get around the unit. The kitchens and the bathrooms are not required to have the 5-foot turning radiuses, only enough room for someone in a wheelchair to pull in and then back out to be able to use all of the appliances. Sinks in the unit need to have lever knobs to make it easier for someone with limited mobility to use them. And bathrooms do not have to have grab bars in them, but there needs to be backing behind the toilet and around the tub shower units so that someone can install a grab bar later if they need to, and that grab bar is going to be set in place firmly and safely. As far as environmental controls like light switches, plug-ins, heat controls, from a side approach in a wheelchair, the operable part of plug-ins should be no lower than 15 inches from the floor, and for things like light switches, heat and air conditioner, no higher than 48 inches. So they're very basic, usable portions of the Act. So when a complaint of housing discrimination gets filed, again, there are varying venues. It can be with HUD, Department of Housing and Urban Development, also with the Montana Human Rights Bureau, and in either state or federal court. Now, if someone wants to file a complaint of housing discrimination with HUD, they need to do so within 365 days of the last discriminatory act. So if something happens today, a complaint should be filed by April 10th of next year. A victim of discrimination can also file a complaint with the Montana Human Rights Bureau, and that has to be done within 180 days of the last discriminatory act. Prior to 1997, the feds, HUD, paid the state of Montana to address all complaints of housing discrimination. After 97, when we changed our law, the federal government decided to withhold that money. So now when complaints are filed, they can be filed with both HUD and HRB, and simultaneous investigations will take place versus a single investigation. If someone is going to file in court, they have 2 years from the discriminatory act to file. But I want to make sure and mention also that when it comes to that 2 years, if a complaint was previously filed with HUD, the time that the complaint sits with HUD for investigation stops the clock ticking on the 2 years. So it may be 3 years later that somebody's filing with HUD, for example, or filing in court, for example. Administrative complaints have time limits for investigation. With HUD, HUD's supposed to be done with their investigation within 100 days. The Human Rights Bureau has 120 days to complete their investigation. And they are required by our Congress and our state legislature to attempt concurrent conciliation efforts. So that means when a complaint is filed, folks will also be contacted about the potential for conciliating the complaint. With HUD in our region, the conciliator is the same person that is the investigator. The documentation is still kept separate so that information released in conciliation is not to be considered in investigation, but it's the same person. With the Human Rights Bureau, the conciliation is done by a separate person, keeping the efforts much more clearly separate. If no conciliation occurs, then a finding and then a charge is issued. If there is not enough information to support a discriminatory allegation, then a finding of no cause is issued. If there is a finding to support the allegations, it's a finding of reasonable cause, and a charge of discrimination is issued. When that happens with HUD, the case is then sent to the U.S. Secretary. Parties can elect to go to federal court or before an administrative law judge, and the case now becomes the United States government versus the housing provider. And victims, individual victims, or organizational victims can then intervene in the case if they would like to. With the Human Rights Bureau, the case is referred to a hearings officer and to appeal to the commission. The person also has the option of getting a private attorney and filing in district court. As with most any law except the 1866 Civil Rights Act, there are exemptions that may allow for discriminatory conduct. In the federal law, if someone has a multifamily complex with 4 units or less, and he or she lives in one of those and handles all management, they are completely exempt from the Fair Housing Act. If they have 3 single-family units and handle all management, they are exempt from the Fair Housing Act. However, our state law only exempts a housing provider if they have 2 single-family units or a duplex, meaning they only rent one of the units because they're required to live in the other, and they cannot seek management services from an alternative source. When it comes to shared living spaces, where, for example, it's a large 4-bedroom house and folks are roommates, roommates can advertise and have a preference based on gender only, or sex. So they can ask for a female roommate or a male roommate. In regards to the state exemptions, the housing provider is not exempt fully from the Act. They're exempt only in regards to age and familial status. So they can deny households with kids only. There are also exemptions for housing for older persons, and that's set up a couple of different ways. 55 and older or 62 and older. And they're exempt again only in regards to being able to deny households with kids. If the housing is 55 and older, it's required that at least one person in the household be age 55 or older in at least 80% of the units. If it's 62 and older housing, 100% of the residents in 100% of the units have to be age 62 or older. And the housing provider is required in 55 and older and 62 and older housing to do biannual surveys to verify the age of residents at the site. Tribally owned and operated properties are also exempt, and they may indicate preferences for tribal members only. Religious organizations and private clubs are exempt if they offer the housing to members only and are not doing so in a way that creates a profit. So that's the, in short, exemptions that exist under the laws. Now the ADA applies only, the Americans with Disabilities Act applies only in regards to public areas such as your leasing offices on a site. The ADA does not apply to dwelling units in open market housing. If the housing receives federal funding, the Americans with Disabilities Act applies. And federal funding can be, for example, a housing authority's properties. Low-income housing tax credit properties in and of themselves is not deemed federally funded. Section 504 of the Rehab Act also only applies in regards to federal funding. So there are several exemptions that can kick into play, can be confusing, and if you'd like more information about that, please call our office. We conduct several workshops and presentations throughout the year, so if you would like more information about discrimination in housing, you can contact us about attending one of our events, or just contact us to talk and ask questions. We serve providers and consumers because we focus on the furtherance of these civil rights. And if we can do that through education and outreach, that's great, but if necessary, we also are more than happy to assist victims of discrimination in housing. So if you have any questions, please give us a call. Our contact information's on the screen. Thank you.